The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as the public records and freedom of information laws. The content may include adult themes, concepts, or language not suitable for all audiences. Viewer discretion is advised. Welcome, everyone, back to my channel and your favorite cubbyhole on the internet. We have much to cover today. And, I've been perhaps a little bit unfair because I haven't done things as sequentially as I would prefer to do. And that's just how things happen sometimes. You get all these filings, you're kind of sorting things out. Sometimes you don't get them in the order in which they have been presented or filed with the court. That's just how she goes. So we're going to do a little catch-up, but since we have already covered the Maraschini side, it's only fair that I cover the craziness on the Laura Owens side of Owens versus Maraschini, or as it seems to be currently, Omar Serrato versus David Gingras, or vice versa, depending on how you like to order things. So we are going to do a bit of catch-up on all of that, and some of it does, in fact, name me. So I may as well cover all of that as well, just as Lauren Knighty and Loud Little Ducky has, because we can. And, someone has some problems, and we'll talk about those problems in just a moment. But first, some community news. That community news is that tomorrow, or at least tomorrow from today's perspective, tomorrow, October 10th, is a hearing for Owens v. Maraschini. And this is an initial hearing to cover some ground and probably take care of some housekeeping items ahead of a trial that's still scheduled for October 21st, unless something changes on Friday. Among those being motions for disqualifying David S. Gingras, Dingus the Douche Canoe.
The fucking douche canoe.
Who can't seem to leave this alone. He's not representing Laura Owens, but yet here he is trying to represent Laura Owens via himself and sticking his oar in the water still. As early as a couple days ago this week, and we will cover that all. But first, let's get to the minor subjects because we wish to be thorough. And this is the notice of an expert witness. Let's embiggen it properly and full screen it because I'm just catching up here. They are offering expert witness John Berryhill, who those of you who have been following this case for a while may recall, did the forensic analysis for Mike Maraschini's laptop from the time in which he was dating Laura Owens. And this is the infamous laptop in which David Gingras rather unfactually asserts that there's 2,500 pages of private stuff out on the internet. I've yet to find those 2,500 pages of private stuff from their relationship out on the internet, other than what little salient details have been discussed publicly by other commentators. Certain people, I think, did receive some of that, if not all of that, for their own analysis, but I have no evidence that any of it has ever been released in totality, other than for the items it covered in Owens v. Eckert in Arizona. So if all of that exists on the internet, which I'm skeptical of because David declares it so, whatever David declares, I'm suspicious of, and rightfully so, because everything he has declared and has, raised his hand to the Bible as a colloquial expression, that he will 100% win all of his cases and appeals and so forth, and none of that has been true. Of course, he's made other declarations recently in video format, but I'm not going to cover all of that necessarily at this time. We may talk about some of those declarations when it becomes important to do so, because some of them are outlandish too. But this little document tells us that John Berryhill shall be called, or could be called, as an expert witness in the DVRO trial. Again, that's still slated for October 21st, so there's really not much to read here other than familiarity. I mean, this is sort of the legal coverage of declaring him an expert witness and all of those things, and that's just submitted for this case. And that, of course, is dated October 7. So that's just a little bit of community news there. And the next little bit is whining and complaining from Laura Owens. An ex parte application for a continuance. And she sent in both. She sent in perhaps with David's help, perhaps not. If he didn't help her even the slightest little bit, I personally would be surprised, but that doesn't matter. Anyhow, this is worth a quick read. And guess what? I think my buttons work. So this is a test. This is only a test. And if it doesn't work, then it'll just sound normal to you and boring to me. But that's all right. So in Pregnancy Faker Voice, we shall read,
Petitioner Laura Owens respectfully requests that the court continue the long cause hearing currently scheduled for October 20 to 21, 2025, and adjust all related deadlines. Good cause exists under the California Rules of Court, Rule that, and D, because of petitioner's medical condition, her father's recent hospitalization, and her ongoing and diligent efforts to secure counsel through approved legal referral programs. This matter has been designated a long cause evidentiary hearing, not cut short or summary proceeding. Given its complexity, the overlapping motions, and the public nature of the record, petitioner cannot adequately represent herself. A short continuance will allow her to secure counsel and participate fully and fairly. My factual background is that there was a family medical emergency. Petitioner's father was hospitalized last week and continues to require 24/7 care. Petitioner has been assisting daily with his medical management. Petitioner has been advised to receive urgent evaluation and treatment for gastrointestinal bleeding. My efforts to retain counsel. Petitioner has been declared indigent by a court in Arizona. She has actively sought legal representation in this case through the San Francisco Bar Association's Lawyer Referral and Information Service, and all for the Family Legal Clinic. She contacted both by October 1, 2025, and remains on their waiting lists. Both have said they will be able to assist if she can wait 2 to 4 weeks. These are legitimate, ongoing efforts showing diligence and good faith. Complexity and public exposure of this matter. This case has been designated a long cause hearing and involves multiple pending motions and evidentiary issues. It has also drawn public attention through a group known as Justice for Clayton, the cult I can't stand so much, which reposts and comments on case filings, and I can't stand that because I really wanted it to be a private matter, and it just bothers me that I can't tell my lies in secrecy, and it has to be exposed where the public can pick it apart and make me look bad because I'm lying, and I've been charged with 7 felonies, and I did nothing wrong other than get pregnant by the effing bachelor. That's my lie, and I'm sticking to it. I also got pregnant by Mike Maricini, and he did bad things to me, and that's also my lie, and I'm sticking to it. The harassment and publicity surrounding this matter are described in prior filings by attorney David Gingras. That's my attorney, David Gingras. Would you like to speak to David Gingras? He's my attorney, David Gingras. He says he's not going to be my attorney here, but he's my attorney, David Gingras. Petitioner requires counsel to ensure filings are accurate, complete, and not misused publicly, even though I've been charged for misusing everything from my sister's sonogram to videos of her being pregnant. Among other perjurious, fraudulent, and other schemes and artifices, I'm indicted on 7 felony counts for. The efforts to resolve them formally have not gone well. My attorney, David Gingras, who's not representing me in this matter, but keeps making filings, just can't get me where I want to be. Petitioner contacted opposing counsel Omar Serrano on October 6 and 7 to request a short continuance while she secures counsel and addresses these medical issues. Counsel is not stipulated to a continuance as of this filing. Under the California Rules of Court, the circumstances that may indicate good cause include the unavailability of essential lay or expert witness because of death, illness, or other excusable circumstances, the unavailability of a party because of death, illness, or other excusable circumstances, the unavailability of trial counsel because of death, illness, or other excusable circumstances, the substitution of trial counsel, the party's excused inability to obtain essential evidence despite diligent efforts. Petitioner's situation satisfies several of these examples. Her temporary medical unavailability, her father's hospitalization, and her documented diligent attempts to secure representation all constitute excusable circumstances under the rule. Further, that rule directs the court to consider all the facts and circumstances that are relevant, including the proximity of the hearing date, whether there had been previous continuances, the length of the continuance requested, and whether the interests of justice are best served by a continuance. Here, the hearing is less than 2 weeks away. No recent continuances have been requested. Petitioner seeks a modest. That's very modest. If it were immodest, I would ask for 5 years while I'm facing my criminal trial. But this is just a 45-day continuance request. And the respondent will suffer no prejudice, while petitioner will face extreme prejudice. I'm so prejudiced by the Justice for Clayton cult that I can't believe it. I can't even tell the court how unfair and how inappropriate this is. But if I'm forced to proceed unrepresented in a multi-evidentiary hearing, it will be so prejudiced against me. Given the factors, the interests of justice are best served by letting me have my way, because I'm Laura Owens, goddammit, and I want my way or I'm gonna have a meltdown. By prayer for relief, will respectfully request from the court that you continue the long cause hearing currently set for October 21 for approximately 45 days, or even more time as the court deems appropriate. And if the court doesn't give me what I want, I'm going to go into a shrieking fit to the judge. I want to adjust all associated deadlines for witness lists, exhibits, and briefing accordingly, and any other such relief as the court deems just and proper. And I, Laura Owens, wrote this on October 7.
Okay, now that we have the dramatic part of that reading out of the way, let's just go back and revisit a couple things, because we've watched Jack Fox analyze the raid on the casita body cam footage. And boy, did he, it's amazing how you get other brilliant people looking at it and you find even more stuff. So if you haven't seen Jack Fox of Never a Truer Word videos on YouTube, I highly suggest you go over and follow him. His analytics are just brilliant regardless, but even more layers of subterfuge and, shall we say, misdirection and control that can be evidenced in those videos is worth the hour. I highly recommend it. Some of you may have seen Jack's appearance with Lauren Conlon, where they've talked about this case a little bit earlier on, and, it's sort of sprinkled along the way. But that is Jack's latest entrance into this case, and it's just riveting. Absolutely riveting when you see the words on paper and him explaining to you what's going on. It's brilliant. It's brilliant. So going back here, we have, various sorts of things. Obviously, this is a stall tactic for Laura, just as was her shrieking and screaming and wanting to do things with her father and controlling things in the body cam footage. This is no different. So we are looking for excuses to delay and all kinds of other things. And we have all kinds of charged words. We have very specific words. Some of them I've highlighted here, and you may have noticed as we went through. Yes, I know, I didn't embiggen it. Okay, we can embiggen it. There you go. All right. I know someone's just going to complain that it's not large enough. We talk about her medical condition, which is all self-inflicted, in my opinion. At least it seems to be evident of that. She's very underweight. She's trying to do like the hunger strike kind of thing, I guess. But she caused it all. So, either get help for it or suffer. Those are your options, really. And trying to use that as leverage to try and delay and prolong these proceedings is not going to make it better for you. And I don't know which way the court will fall on this. I'm not sure the temperament of the court in these sorts of issues. And we'll just have to see what happens on Friday. But we like to use her issues. We're talking about her father's issues. We don't know if those are legitimate or not. There is no evidence of such given in these declarations and in this application for a continuance. I mean, it should be a motion for continuance, I would think, but what do I know? And we whine and we complain and we say that that she, being Laura Owens, is involved in his daily medical care. She didn't even seem to have any clue, as we saw in the police body cam footage. She didn't even know he used the walker that was sitting right there next to his bed. And he doesn't even use a walker. You all know what we're talking about. He can't sit in that chair. Honey, that's the chair he uses all the time. Remember all that stuff? She is out of touch. She's out of touch with reality, as is, I think, the rest of her family for the most part. And this is just more of the same. It's to deflect and hide and delay and control. And it's just outrageous. And in talking about her medical condition, whether or not she has one is also unclear because there's no evidence given that she has further things. And it's the word advised. She's been advised to receive urgent evaluation. No, it's not that, okay, you've got a problem and you need to go in and you need to go to the ER and have it evaluated. We're just advised. So what telehealth thing have we talked to advise her? Just like, we're advised that we're no longer pregnant, or we're advised that we are pregnant, and we're advised that we have a high-risk pregnancy. All of these distance words that suggest to us there's some misdirection going on here. There are lots of things that can cause gastrointestinal issues, whether or not there's bleeding or not. Anytime you bleed, let's just be medically succinct for a moment here. Bleeding from anywhere unexpectedly is a problem, and it should be evaluated by a healthcare professional in person, not on video, not telehealth, not on the phone. If they're telling you to get your ass to the ER, that's what you do. It's not you've been advised to go in and get treatment. These are things you do. They're not things you wait for the court to give their blessing on doing. So to me, this seems like a stall tactic. And we whine about our efforts to retain counsel. Well, Sugar Tits, you filed this motion to continue it. And maybe you thought yours and David's little ruse of him saying that, well, I'm not going to represent her, but he'll leave the door open to walk in to help her, didn't work out for you, did it? You shouldn't have brought this renewal in bad faith, is my opinion of it. And if you didn't have legal representation at the time of filing, and you were stupid enough to file pro se this action, thinking that Mike Maricini was just going to be a pushover because you're such a controlling bitch, that's what you're used to. But Mike had the fortitude to actually hire legal counsel not once but twice, essentially, with Omar Serrato and Rachel Juarez. And now perhaps someone is feeling the walls closing in on them. So now we have to, oh God, Rachel and Omar are coming after me. I need to find legal counsel. No, I won't use the voice for that. But I think the walls are closing in. And now we realize that there's problems. And now we're going to try and hit the pause button so we can scramble and delay and try and find a defense that we didn't have before, because all the crap she filed before isn't working. The hearing on Friday will be very interesting. With any luck, we may be on top of that, as will my colleagues in this area of case discussion. We'll see how that goes. It will be absolutely fascinating. I am told that there will be a number of observers. I won't say who they are, but we'll see. We'll see what the reports on the ground are at the time and when that comes back to us. So we'll all be watching the interwebs closely for the results of this hearing on Friday. And of course, she whines about the public exposure of this. And she says specifically, as we said earlier in Laura Owens' voice, pregnancy faker voice, it has also drawn public attention through a group known as Justice for Clayton. And we notice the lack of the word cult. Now, maybe that was a word David used all the time to try and denigrate and invalidate the opinions and views of people watching this case in the public. But of course, we repost and comment on case filings. And what she's going to try and do, as she's done all before, is to try and make things a private matter, try and keep things secret, and so on and so forth. And I don't think she stands a leg on that in this case or cause either. And naturally, because she's a vindictive, nasty woman, she keeps assuming that people talking about her not in the positive, which is our right to do, free speech, tough shit. Of course, she claims that it's harassment, all the publicity, all the negative publicity she's getting. Well, sweet thing, you've got 7 felonies. No one has to be nice about characterizing you as the criminal you seem to be. And once there is a conviction, in my opinion, that will brand you for the rest of your life. And those were the choices you made and the behavior you have committed in all these years against all these men and all these other people. It's just deplorable. It's deplorable and it's disgusting. And you deserve to be in prison for however long the court decides to sentence you. And of course, she continues talking about opposing counsel, and he has not given in to her. And I don't expect Omar to give her anything, as his right as counsel for the accused, and they are fighting back. There's really not much to say about the rest of it. We try and make comparisons that if we whine about having a cold or COVID, it's just, we're not going to participate in the motion, the action she brought. Yet again, another cause of action she brought in bad faith is going to be the straw that breaks the camel's back will be the metaphor I will use at this time. I was thinking another one, but I decided it would be in poor form to use that particular metaphor involving trees and other things. All right. So there's that little thing. That's enough to cover this, because what we want to talk about is the highlight for today. And that highlight is, I've got to switch images here. Okay, hang on just a second. Hold, please. Okay. We need to talk about the hate boner being displayed by David S. Gingras, Esquire.
The fucking douche canoe.
Alleged former counsel for Laura Michelle Owens. And the soon-to-be, I hope, I don't know which way this is going to go. I assume that the court is not going to put up with the antics. And I presume that Dingus the douche canoe will be disqualified. But we shall see. We shall see. But David Gingras has a hate boner for YouTube and anyone that doesn't suck up to him and his alleged former client. I say alleged former client because he keeps making filings and motions as a, air quotes, intervener in the DVRO case. So clearly he's trying to represent her without representing her and making a formal appearance, for which he's already been requested to be disqualified, and we'll have to see how the court rules on that matter. But he has an obvious hate boner against people on YouTube, myself included. So to back up just a little bit further, we have to talk about how all of this motion practice between Omar and David, and including Rachel Juarez, just a little bit more. And I kind of missed this. I sort of started a little bit out of order because I wasn't paying attention to all the dates on the filings. But we have to go to this point where things kind of started with David slapping himself in and waltzing his way into this cause of action. In the middle of September, David made a filing in the case between Laura Owens and Michael Maricini, his notice of motion to intervene, strike, sanctions for and the bar referral for Omar. We've kind of talked about that in Omar's responses, which is where I sort of picked this up after some time away in September. And this is where this slap fight sort of begins. And the slap fight, you know, it's all a disparagement, character assassination on David's part against Omar. For all the obvious reasons, because that's the way David operates. And anybody who speaks against him and speaks against his girl Laura, and I'm going to use that phrase rather deliberately, because I believe David has an infatuation with Laura. And I believe that infatuation goes beyond the normal course of conduct and duty. That's about all I'm going to say about that at this time, because it's not normal attorney-client privilege and relation. It seems to go beyond that. And Laura's running to David via telephone when they were raiding the casita sort of suggests there's a little more than just, he's my attorney. We certainly use David as a shield, just as we use mom and dad as a shield for being held accountable for our allegedly criminal actions. So now we'll play a little catch up and we'll read the filing that kind of started this back and forth tug of war of, I know you are, but what am I? Which I will say, to Omar's credit, he hasn't engaged in that, but he has very specifically called out David on his erroneous and fallacious and, in my opinion, fraud upon the court. Many of David's accusations are not based on law or fact, even in these filings. And yet we're trying to reuse the same arguments that were proffered at the beginning of this cause of action to make the restraining order permanent. So brace yourselves. This one's a little bit lengthy, as is the next one, because David can't be succinct. He has to ramble on incessantly. He likes bloviating, but you're going to get a full treatment of Douche Canoe Esquire.
Please take notice that on October 21, 2025 at 8:30 a.m., or as soon thereafter as the matter may be heard in Department 405A of the above entitled court located at 400 McAllister Street, San Francisco, the court in which we will hear the case, intervener David S. Gingras intervener or Gingras, will and hereby does move for an order imposing sanctions and other relief on respondent's counsel, Omar Arcerado, on the following grounds. This motion is brought pursuant to California Code of Civil Procedure 125 and is based on this notice, the attached memorandum of points and authorities, and such papers, pleadings, and argument as the court may allow. Intervener, but not legal counsel for Laura Owens, who hasn't made it an official appearance yet, seeks the following relief against Mr. Serrato. An order imposing sanctions and fees on Mr. Serrato based on his making knowingly false statements to the court and for pursuing bad faith tactics that were frivolous and solely intended to harass in violation of CCP 1.85. An order striking the motion to disqualify, filed by Serrato on August 25th, and an order finding Mr. Serrato's conduct in this matter has violated the following rules of professional conduct, prohibiting a lawyer from taking any position in litigation without probable cause and for the purpose of harassing or maliciously injuring any person. Rule 33A1, prohibiting false statements to a tribunal. Rule 4.1, prohibiting false statements made to third parties, prohibiting conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation. An order referring Mr. Serrato to the State Bar of California for investigation and discipline as appropriate, and any such further relief as the court deems proper. In his motion to disqualify, respondent's counsel Omar Serrato lied to this court. Specifically, in his motion, Mr. Serrato falsely avowed that I, undersigned counsel, continues to represent petitioner Laura Owens, Miss Owens, in this case. That undersigned counsel has a current personal conflict of interest that materially limits his ability to represent petitioner. And 3, that allowing Mr. Gingras to continue as counsel or prejudice respondent's rights and undermine the integrity of these proceedings. Mr. Serrato's representations are all lies. His statements are knowingly false. Mr. Serrato knew his statements were false at the time they were made, for one simple reason. Days before his motion was filed, he was told repeatedly, both by phone and in writing, that undersigned counsel no longer represented Miss Owens in this matter. The details of that issue are explained in the declaration of counsel submitted herewith. Why on earth would any lawyer lie so blatantly to the court under these circumstances? There appear to be 2 primary reasons. First, Mr. Serrato had some sort of bizarre personal obsession with and hatred for the undersigned. Indeed, over the last 12+ months, Mr. Serrato has posted multiple videos on YouTube falsely smearing, defaming, and attacking undersigned counsel. Bullshit! One such video contains an image that depicts Mr. Serrato physically assaulting, choking undersigned counsel with a caption that arrogantly and menacingly boasts, Gingras doesn't want the smoke. See attached YouTube link.
That's a pretty hunky picture, I must say. Gingras doesn't want the smoke. Turns down our invitation. I remember that when David threw in the towel because he didn't want to look silly in front of Omar. The way he ended up looking silly in front of Reality Steve and Rachel Juarez. How ironic that Rachel's back in this one. I wonder if David's worried.
Mr. Serrato has also made similar threatening statements, publicly disparaging and attacking Miss Owens, in the context of discussing her actions in this case. In those public comments, Mr. Serrato again used the same gang violence-inspired threat to Miss Owens, accusing her of fraud, in this case, that she wants all the smoke. See attached YouTube. If the court is not familiar with the term, and hopefully it is not, asking a person if they want smoke is used as a threat of physical violence, as confirmed by the image of Mr. Serrato locking undersigned counsel in a chokehold. The term carries an implied reference to gun violence.
And here is an entry from Urban Dictionary, which is why I used an Urban Dictionary to define hate boner, which is what I believe David has. David has a hate boner against Omar and probably Rachel Juarez, and most definitely against Dave Neal, and most certainly against Lauren Nighty, and to some degree Loud Little Ducky, and even myself, which we'll get to in just a moment.
In any context, Mr. Serrato's threatening words and conduct would be inappropriate. In the context of this DVRO case, it is inexcusable in the extremest of extremes. This case involves a domestic violence restraining order against respondent, Michael Maricini, an order he initially stipulated to. This court previously found Mr. Maricini violated that order, resulting in a 5-year extension.
Bullshit.
Shortly before the extended order was due to expire, Mr. Mancini violated again, multiple times by releasing 2,500 pages of private text messages he exchanged with Miss Owens, and by traveling to Arizona and coming within 300 feet of Miss Owens, despite clear and unequivocal warning such interstate travel constituted a serious federal crime.
Okay, I think I've had enough of douche canoe voice already. We might switch voices. We might go back to something a little bit more familiar to me and more fun. We've talked about this. Mike had a valid subpoena. He was called as a witness. He was subpoenaed as a witness. He was required under that subpoena to show up. This is pissing into the wind and trying to falsify and misrepresent what actually happened, as only David can. So in my view, and hopefully this will be pursued and considered by the court, this is sanctionable offenses right here because it's false and it's misleading and it misrepresents what actually happened, as Omar very skillfully covered in his response. And now that I've remembered to make it properly big, we'll keep going. As a victim of this unlawful and criminal conduct, Miss Owens has come to this court asking for help a third time. In a clear attempt to silence and intimidate her, Mr. Mancini's counsel, Mr. Serrato, responded by posting YouTube videos on YouTube threatening Miss Owens, and now her former counsel, with physical violence. Okay, we'll use that voice. Why not? Why the hell not? Compounding that misconduct, Mr. Serrato blatantly lied to this court about the status of the undersigned counsel continuing to represent Miss Owens. I think she's rather cute, and I would want to keep representing her till kingdom come, but it's a statement he knew was false at the time it was made. He then put those lies into a pleading, which he knew would be transformed into multiple YouTube videos by his friends, resulting in Mr. Serrato's false attacks by being placed on the internet permanently. I don't know the difference between the internet and interwebs, but I think there is a difference. Something seems a little stickier, but I can't tell you which. But this conduct by Mr. Serrato should not make this court angry. It should make this court furious. My blood pressure is so high I can't even get enough purrs out of my cat to make me feel better. This leads to the second apparent reason for Mr. Serrato's dishonesty. Although he is a licensed attorney, Mr. Serrato's primary focus appears to be making money from his YouTube channel, where he refers to himself as the tilted lawyer. It gives me a tilted boner, just like it does Dave Neal. And, well, if we're talking about tilted boners by the tilted lawyer, maybe we should just not talk about that and just plead the fifth.
I plead the fifth. I plead the fifth. I'm not going to get myself criminally in trouble. I plead the fifth. I plead the fifth.
Yes, I do. I plead the fifth about that tilted boner. He's quite a handsome fella. But if I were to have friends in Florida, like what's his name, Bruce Manskin, is that his name, Bruce Manskin, and that polyflop thing, that polyandry? No, I think it's a polyflop. I forget what it's called. Poly something. Polly want a cracker. You know, that's accusing people of doing stuff in the courts just to make YouTube content, although there's no such laws. It's just a bunch of bullshit. But us small penis types like to talk about polyflopping all over the place and all of that extremely lucrative YouTube content. But like I say, as the court may or may not be aware, because I represented all kinds of nasty people in my past that would make hundreds of thousands of dollars in YouTube content. YouTube can be extremely lucrative, but there is just a problem that creating content is hard. It was hard for me in all the things I tried to do with Laura and being her PR agent. That didn't go very well. She was just insatiable. I was doing them all the time, and I couldn't get enough of her on that YouTube video. All that YouTubing makes you require lots of new material on sometimes a daily basis, and leading to an insatiable desire for new content at any cost. My desire was so insatiable to have Laura on, we had to give it up at some point, and then it just became unsustainable, and I unlisted all of my videos. Also, to gain the most views and to earn the most money, you need to have new videos with eye-catching, scandalous, provocative things. All kinds of eye-catching things. Seeking social media money and stardom, Mr. Serrato chose to file in an utterly groundless and frivolous and needless motion as a way of creating new YouTube content. He gave it to his friends. Posting a video about this motion on his own channel would be so sleazy, be too sleazy even for Mr. Serrato. Instead, Mr. Serrato filed his pleading and waited for his friends to make videos laughing about the scathing allegations contained in the motion. That plan worked exactly as Mr. Serrato intended. I wanted to name this conspiracy right from the beginning before Laura even filed this action against Mike Mancini. I knew there'd be a conspiracy. Shortly after the motion to disqualify was filed, Mr. Serrato's friends created multiple videos reciting every false statement in Mr. Serrato's motion. And here's all those YouTubes. That YouTube of that smiling young lady who swims so nicely in the swimming pool, that Laura Michelle. She talks about me all the time, and I can't stand it. I even tried to false copyright strike her so many times to shut her up. It didn't work either. Then Mr. Serrato got involved in that, but I don't want to talk about that because I got my ass whooped there too. And that loud little ducky, squawks and squawks and squawks. She's been talking about me a lot, and I don't like that. I don't like that at all. I might have to do a couple more copyright strikes on her that are frivolous and fraudulent, and maybe that will quiet her from talking about me and talking about my girl Laura and in not so nice ways. But I just can't stand her. And then there's this new guy. I don't know. I haven't seen his face. He uses a picture of a Greek god that's better looking than I am in my gym attire. He's that Tabernacles from the Echo guy. He even talks about me. I didn't know how much till Laura told me. He's got all kinds of videos. He's got like almost 60 videos talking about me and Laura. It's insane. It's absolutely insane. I don't know why his channel isn't bigger. He should be monetized at this point. But I'm going to say he's monetized, even though he's not. I'm just going to lie myself to the court and hope that the court doesn't figure it out. But it is false. That Echoes guy and Ducky, they don't have monetized channels, but we'll say otherwise because it makes me look better. Even if it is fraudulent, even if it's bringing fraud on the court, that's okay. I don't mind. I did that with Laura's paternity trial, and we filed all that stuff, and Laura had all those fraudulent videos and medical thingies, and we even brought in that med show guy that talks about dribbling and shooting. Didn't find anything credible in anything we presented, but I did the best I could until I had to try and appeal everything, and it didn't go well there either. By bringing a groundless motion based on knowing the false statements made solely for purposes of harassment and YouTube fame, Mr. Serrato violated California Code 128 blah, blah, blah. As a result, this court should impose substantial financial sanctions to deter similar future conduct. You know, I'll lie to the court all I want. I don't want to be slapped down for doing things like that, but he should. He should. Rules for thee, but not for me. This should include, at a minimum, a financial penalty payable to the clerk of the court for Mr. Serrato. I haven't read this. Can you tell? It might crack me up from time to time, the stupidity of some of this. Okay, sorry. I broke character. I apologize. An award of fees, costs, and expenses incurred in bringing this motion. Mr. Serrato's conduct also violated multiple rules of professional conduct. The violations include 3.1, prohibiting a lawyer from taking any position in litigation without probable cause and for the purpose of harassing or maliciously injuring a person. I wasn't injured at all, but I want to pretend to be a victim just like Laura. Laura taught me pretty well on how to play the part of a victim. And if you don't get your way, just scream and yell obscenities at everybody, and maybe they'll give in once you wear them down enough. I should try that. I should try that more with my wife. Rule 4.1 also prohibits false statements to third parties. Third parties like those boob tubers up there, that Lauren and that Ducky and that Echo dude. They're definitely third parties. I know for sure that Mr. Serrato was talking to them and just waiting for them to do their jobs like he instructed them to, of disseminating this very private public filing. It's all very private. It's all very private, even though it's public filing. Didn't you know that? Yes, that's right. That conduct involved dishonesty, fraud, deceit, reckless and intentional misrepresentation. The facts clearly show Mr. Serrato intentionally violated each of those rules. Let's not talk about how I'm violating them, or Laura. Never mind. Accordingly, in addition to those other sanctions this court may impose, it should also strike the motion to disqualify, because I still want to represent Laura, even though I'm not representing Laura, and that's what I told the court. The court should find Mr. Serrato took positions without probable cause and solely for purposes of harassment, and that Mr. Serrato knew in his statements that they were false at the time they were made. Based on those findings, the court should refer this matter to State Bar for investigation, just like I'm being investigated to the hilt in Arizona, and I can't stand that bar dude, and I'm going to sue him until he drops the frivolous disciplinary action proceeding against me in the State Bar of Arizona. A summary. I like summaries, because I write so much I need AI to do a summary for me. This isn't AI, I just keep typing. Mr. Serrato's misconduct aside, the facts of this case are quite simple. In 2018, Ms. Owens obtained a DVRO in this court against respondent Mike Maricini. As the docket reflects, Mr. Maricini stipulated to the entry of the original order, an order which Mr. Serrato now claims was obtained by fraud. 2 years later, in 20, Miss Owens accused Mr. Maricini of violating that order again, even though they weren't together and Laura's just about to move across state lines. This resulted in the court renewing the order for 5 years, and it expired just this last July. On July 9, 2025, Miss Owens filed the request to renew the order permanently against Maricini based on 2 different events. First, Miss Owens alleges that in mid-2024, Mr. Maricini released 2,500 pages of private text messages exchanged between parties in 16 and 18 while they were dating. In fact, standing alone, this would be sufficient to find a violation of the DVRO, in my not-so-humble, bloviated alcoholic opinion. In that mentioned misrepresented court case, it was found that the wife properly alleged abuse where her ex-husband accessed her emails without consent and released contents to third parties explaining the husband's alleged conduct of viewing wife's private email, learning her social schedule, communicating this information to other people, could constitute indirect and threatening contact and thus abuse within the meaning of section that there, and so on and so on and so forth. And we'll skip some of this because it's just more blathering on. I like to hear myself talk. It's not bloviating like that Echoes dude says. It's pontificating because I dingus the douche canoe. I'm a fucking genius. Second, Miss Owens alleges that Mr. Maricini violated the DVRO's proximity restriction by coming to Arizona in June of 24, as he was rightfully subpoenaed by the court, and coming within 30 feet of Miss Owens outside the courthouse. She was so close and within the courtroom that we could smell his aftershave, and he smelled kind of pretty. Maybe not as pretty as Clayton Echard, but damn close. I'm not sure who was the prettiest. If Omar Serrato in there, we would have all had tilted boners too. Miss Owens is going to allege that by engaging in that travel that he intended to violate the court's order. Mr. Maricini both violated that order and committed a criminal violation of the Violence Against Women Act. His mere presence is such with that nice-smelling cologne that it just violated everything. And we'll skip some more of this because this is all bullshit. Miss Owens' request to renew the DVRO was filed pro se, which means without me, but I'm going to try and enter in a back door just like I enter other people's back doors. Never mind. At that time, the undersigned declaration was solely submitted in his capacity as a witness, not as an attorney representing Miss Owens, although I did make that limited appearance for the initial thing, hoping that Mike would just roll over and give Laura what she wanted just like her family does. That declaration explained undersigned counsel previously represented Miss Owens in the paternity case in Arizona, Owens v. Echard. The declaration explained during the proceeding Mr. Maricini was initially disclosed as a potential trial witness, but Mr. Maricini's counsel later indicated in writing, and when I'm going to relitigate everything I've whined about before, that he would not appear, even though that wasn't accurate, despite the subpoena the court issued. Despite this, shortly before June 10, Mr. Maricini publicly released 2,500 pages that we still can't find, but we're going to claim are out there somewhere. This was done without a subpoena or court order and without any formal discovery request for the litigation of Owens v. Echard. Mr. Maricini simply leaked this private information, which resulted in thousands of his private messages, with Miss Owens being posted on the internet, where they remain to this day. We have no facts of that. We can't provide any link for that, but we're going to claim that to character assassinate Mr. Maricini. Because that's what this is all about. We're going to assassinate the character of Mr. Maricini, and we're going to do that of Mr. Omar and just about anybody else who takes anyone else's side but Laura's. And if they don't do what we say, we're just going to throw a hissy fit just like she did in that body cam footage. She's just going to scream and bitch and yell and call you nasty things until she gets her way. So you better do it. You better do what she says, because that's what she's going to get used to. In addition, the declaration of me, undersigned counsel, explained that June 10, Mr. Maricini was really close to Miss Owens out in the parking lot. That resulted in undersigned contacting law enforcement, which I called 3 different departments to get her way because Laura was having a shit fit. That he was within 200 years of her. Because undersigned counsel is a witness to the variance, preliminary decision was made not to represent Miss Owens in the matter, even though such representation could be permissible under that code and rules there, them rule thingies, and allowing me to be both. I don't know how I'd cross-examine myself. We'll just have to see what happens when we get to that point. That could be very exciting for me. I've always wanted to be 2 people at once because I'm just not full enough, or I'm not a complete enough man without at least duplicating myself once or twice. Despite this, Miss Owens learned that Mr. Maricini retained counsel. She asked the undersigned to represent her on a limited scope basis for the purposes of that first hearing. Undersigned briefly appeared at the hearing, but has never filed a notice of appearance in the case and is not Ms. Owens' counsel of record. Despite that, I want to be an intervener. That means the same things. I want to represent her without representing her, without officially making an appearance. I think if I do that, then they can't sanction me for anything because I haven't officially made an appearance. But if I'm an intervener, then I can make demands and try and get some money out of it, just like I filed for, all that motion to sanction and bullshit like that. Following that discussion, undersigned counsel spoke with Mr. Owens about the issues. During that conversation, a decision was made that undersigned counsel would not continue to represent Ms. Owens in the case and all those reasons there. Determination of representation of Ms. Owens was reported to Mr. Serrato by phone with Miss Rachel Juarez, that lovely hot bench lawyer. They don't call it hot bench for nothing. But she was on it too, and that call asked, oh, wait, no, that's not the call. That's just a 16-minute call, and we had that 66-minute call where both Rachel and Omar were ganging up on me. I couldn't stand that. I didn't have Laura to defend me there either. She was off doing something else with I don't know who and what. Later that same day, Mr. Serrato sent me the email requesting verification of all my rambling and carrying on and talking about my bar guy and talking about my DUI douche canoe problem. And I just kept going back and forth, and we were just talking about all kinds of stuff. I don't know why they couldn't follow me. Maybe I was cracked out on something. Maybe I wasn't. I will neither confirm nor deny. I may just plead the fifth.
I plead the fifth. I plead the fifth. I'm not going to get myself criminally in trouble. I plead the fifth. I plead the fifth.
I love that button. Yes. Maybe I was just having a good day, or maybe I was off my meds. I just don't know. Maybe I had too much coffee. 66 minutes, and we just talked about all kinds of stuff. And, well, I just was, I do what I always do, and I just run my mouth. You might have to step on my toes to get me to shut up. Later that same day, counsel responded to Mr. Serrato via email and said, yeah, it confirms that we talked about that, and you caught me with my pants down, so to speak. I was trying to sneak in the back door, and it didn't happen. But I was so shocked later. That next day, it was unclear whether the first, and all that, I had some problems with my email. I thought for sure after all my yammering on to them for 66 minutes that it took me 7 hours almost to send an email from that time of the phone call. I immediately sent it. I swear by all that's good and holy on Laura's backside that I sent that. But for some reason, it was still sitting open on my desktop, yet it was sitting in my sent message folder. Can you imagine that? It's just like Laura's twins evaporating into thin air. I had 2 emails at the same time in 2 different places, just like 2 different babies, 2 different gender babies at that, a boy and a girl. I can't explain it. But I swear. So I did a whole nother email that was a lot shorter than the first one. Despite knowing the undersigned counsel no longer represented Miss Owens, I was shocked that Mr. Serrato would go behind my back and seek a motion to disqualify me and counseling her in the case. In his motion, Mr. Serrato falsely represented to the court that undersigned counsel continued to represent Miss Owens, in fact, which Mr. Serrato knew was false at the time it was made. Indeed, Mr. Serrato clearly knew the entire basis for his motion, that undersigned counsel continued to represent Miss Owens, was false. All that whole verb tense fighting back and forth. Based on these facts, the undersigned counsel requests leave of court to intervene in this matter for the limited purpose of bitch-slapping Omar because I want some money and I've got to pay my Dewey Douche Canoe filing fees and all the stuff that my continued court trial against my Dewey, I got lawyers to pay myself, and they ain't me. So I need some money, and I'll get it any way I can. But I also want to bitch slap Mr. Serrato and get him referred to the State Bar of California, just like Judge Mata ruled against me and referred me to the State Bar of California. Now they're taking that up seriously. I don't like that at all. I'm going to have a shit fit, hissy fit like Miss Laura Owens until I got my way, too. My rationale for all this, if you can believe it, I try and have a rationale, but no one believes me, and I've discovered that no one believes because I'm not a good lawyer, but I keep trying anyhow after 25 years. They don't call it practicing law for nothing, but my practice is pretty shitty. To begin, despite having appeared briefly for Miss Owens at a short hearing, the undersigned is not party to the matter. As a non-party, I arguably lack standing to seek any relief. So he admits it. Arguably lacks standing to seek any... I'm sorry, I'm breaking character again. Including sanctions. So why are we doing this? We're wasting the time. We're running up the tab. We're trying to make this as painful and expensive for Mike as possible before Mike inevitably wins. That's what this is about, in my view. As non-party, the undersigned arguably lacks standing to seek any relief from the court, including sanctions, etc., etc., etc. For that technical reason, and because I want something from all this for doing nothing, I want leave to intervene. My leave to intervene is sought pursuant to that CCP there for the limited purpose of getting money from Mr. Serrato. Under that provision, the court may, upon timely application, permit a non-party to intervene in the action or proceeding if the person has an interest in the matter in litigation or in the success of either parties or in an interest against both. I certainly have an interest in Laura, but that's not about money. That's about something else. Permissive intervention under CCP is appropriate if the proper procedures have been followed. The non-party has a direct and immediate interest in the action, which I don't, but I still want the money. The intervention will not enlarge the issues of litigation, which they have, and the reasons for the intervention outweigh any opposition by parties presently in the action. Well, Laura says I can do what I want because she's my sugar mama, at least in terms of social clout. You know, that Owens name has a little bit of clout behind it. I want to squeeze it for all it's worth. Here, leave to intervene is requested solely based for the limited purpose of seeking sanctions and money from Mr. Serrato based on his outrageous, unlawful, and unethical misconduct. This litigation will not in any way expand or enlarge the other merit-based issues in the litigation. Indeed, the request for sanctions is entirely unrelated to the merits of this proceeding, even though my absolutely horrific motion practice will carry this on indefinitely until I get tired of it or the judge slaps me out of the court. I'm not sure which will happen first. The sole question raised by this motion is whether Mr. Serrato engaged in misconduct sufficient to support an award of sanctions. Resolving that simple question will not affect any other aspect of the dispute between Miss Owens and Mr. Maricini. Accordingly, leave to intervene should be granted for this limited purpose, assuming the court agrees relief cannot be granted to a non-party. So I'm going to make myself a party by calling myself an intervener so I can get some money and hopefully get Mr. Omar in trouble. That's my whole goal here. And just make a mess of this whole thing and hope that it gets so messy that Laura gets off scot-free and doesn't face yet more criminal charges here in California, like she is in Arizona. As the court's aware, those rules provide that a trial court may order party's attorney, or both to pay reasonable expenses, including fees incurred by another party as a result of actions or tactics made in bad faith. That doesn't include my actions. None of my actions are in bad faith. But I'm going to say that Omar's are because I want money from him. That's what this is all about. Anything that's frivolous or intended to cause unnecessary delay. Well, my getting money from him isn't a delay for me. I just want the money. For the reasons explained above, Mr. Serrato's motion to disqualify was objectively frivolous and made in bad faith. At the time the motion was filed, Mr. Serrato knew that the attorney-client relationship between the undersigned and Miss Owens had ended, and that undersigned avowed that he would not appear any further in this matter as Miss Owens' counsel. Knowing this, there was no legitimate reason for Mr. Serrato to ask this court to disqualify Miss Owens' counsel, who was no longer her counsel. I mean, I was hoping they'd keep the back door there so I could walk in the back door, but they're taking it out. They're sure trying, at least. Nevertheless, Mr. Serrato falsely represented to this court that the attorney-client relationship was continuous and ongoing. We won't talk about how it's ongoing because that's a personal issue between me and Laura. But arguing relief was required to eliminate a clear conflict of interest, a conflict which Mr. Serrato knew did not exist. The sole basis for the alleged conflict was the concurrent role of the undersigned as both Miss Owens' counsel and as a witness. But Mr. Serrato knew such conflict existed because he knew the undersigned was no longer representing Miss Owens at the time the disqualification motion was filed. Mr. Serrato simply lied about this fact to the court for the purpose of creating false, non-existent basis for him to file a disqualification motion that falsely accused the undersigned of professional misconduct. I've got so many of those in Arizona, I don't need them here in California, but I have a feeling they're coming. Oops, this court should never accept intentional dishonesty from any lawyer appearing before it. As officers of the court, attorneys may never engage in deliberate dishonesty towards a tribunal. Because Mr. Serrato broke that most inviolable rule, this court must impose significant consequences to deter any future misconduct. The safe harbor provision that I ruled about with Rule 26 in Arizona certainly won't ever apply to me. I get my way just like Laura does. So when a party or Laura violates that CCP, this does not always support an automatic award of sanctions. Rather, like its federal civil counterpart, it contains a safe harbor, which I know very well because I was whining about Rule 26 all the way through the appellate courts. In most cases, the safe harbor precludes an award of sanctions unless the violator is served with a draft motion for sanctions and an opportunity to fix within 21 days. That has not occurred here, but this is no barrier to sanctions. This is so because the safe harbor provision does not apply and in any case where the violation causes harm, which could not be cured with withdrawing the offending pleading or tactic. Specifically, the rule is clear. The safe harbor applies only if the alleged action or tactic is the making of a written motion that can be withdrawn or appropriately corrected. In other words, if the violation arises from a pleading or tactic that cannot be corrected because the violation has already caused harm which could not be cured by withdrawal of the pleading, then the violation is incurable. In that case, safe harbor does not apply, and sanctions can be imposed without the 21-day period. I give this marriage thingy, in which case I think it proves my point, but it doesn't really, so we'll skip all that. The court of appeal caused harm, blah, blah, blah. Shanefeld, blah, blah, blah. Safe harbor, Rule 26, Rule 26, Rule 1126. Rule CCP. Mr. Serrato's misconduct also includes making threats of violence against Miss Owens and myself. But I'll say Miss Owens because it looks better. And the undersigned. Oh, that is me. I forgot who the undersigned was for a minute. And filing a frivolous pleading containing false and defamatory statements, attacking the undersigned, which he knew would be turned into lengthy polymop YouTube videos by his friends, which is exactly what happened. Mr. Serrato's scheme intentionally caused the permanent online distribution of the false statements in the motion to disqualify. I think all court proceedings, because I'm a douche canoe, should be private. I don't want anyone knowing my dirt out there when I get it wrong. I certainly don't want anyone else getting my dirt out there when I get it wrong, because it makes me look bad, and I don't like looking bad. And when I go on a Dewey Bender, it makes me look even worse. So I just can't stand anything being out on YouTube. You know, I claim to be a First Amendment lawyer and an internet defamation and all that kind of jazz type of lawyer, but I really don't know shit about it. I certainly don't know what First Amendment means, especially when I go false copyright striking everybody that I don't like. Disciplinary referral to the state bar is certainly appropriate. In addition to imposing economic sanctions on Mr. Serrato, so I can get some money back in my tail because I'm not making very much right now, showing up for lawyer as the dutiful legal boyfriend, this court should go even further because I'm a salty bitch. The court should also make specific factual findings that Mr. Serrato has engaged in intentional dishonesty by filing a pleading which he knew contained false statements. The court should separately conclude that Mr. Serrato's bizarre and threatening online posts and attacks against my girl Laura should constitute a separate basis for discipline. Mr. Serrato's actions in this case closely mirror those which resulted in the recent disbarment of a Florida lawyer in Florida Bar versus Lee. What if that has anything to do with Lee's that we know? Fleeces? No. Could that be? Wouldn't that be something? Oh my God. We may have to look that one up, ladies and gentlemen, but not right now. We got to finish this. We got work to do. In that case, like here, the lawyer posted a series of threatening online images attacking the opposing party and counsel. Among other things, that lawyer posted a picture of a Tommy gun being fired at a movie theater character from Damascus with the message, "Me, the next time I'm in front of the Liverpool back line. You guys suck." Based on that conduct, among other things, the Florida Supreme Court ordered the attorney disbarred. Here, especially in light of recent events such as the public execution of conservative commentator Charlie Kirk in Utah, threats of violence, even if made jokingly, are completely and totally unacceptable. Mr. Serrato's threats to bring the smoke, made both to Miss Owens and undersigned, may appear funny to him, but they are absolutely no joking matter, especially when Mr. Serrato has not only extended threatening words, he also took the time to create a childish image that shows him with bulging, muscular arms, holding me and about ready to kiss my not-so-balding head. That's an old picture of me. I've got a little bit more receding hairline, but he can kiss me on the cheek. Talk about tilted boners. Oh, my goodness. I plead the fifth.
This'll get awkward.
And the undersigned in a chokehold. Ha, ha, ha. Never mind that in previous videos that I made that I've since unlisted, but they're still available. I talk about Omar being dead to me while showing guns in my background and some other things while waving and brandishing my firearms that I showed up with on June 10th in my car because I was just so afraid of my life for myself that I brought weapons to the court. I don't know if they were secured properly. I can't remember, and I'll neither confirm nor deny how they were in my car at that time, especially with recent Dewey events. I may not even be allowed to have weapons right now, but never mind that. Mr. Serrato's conduct before representing anybody related to Miss Owens and this nonsense is not funny. It's illegal. It's as illegal as me getting a DUI. It's unprofessional. Just like my getting a DUI is very harmful to people should I hit somebody and kill them. And it's also wholly inappropriate for an officer of the court under any circumstances. But, you know, I shouldn't be allowed to be prosecuted for a DUI. I should just be allowed to get away with it scot-free. And that's why I'm continuing the continuances in perpetuity until the court stops me. This is doubly true in context of the given case of domestic violence and so forth. Even worse, this appears to reflect a pattern of misconduct, as is not the first time Mr. Serrato has been accused of lying in court. Even though this whole case had nothing to do with that, I'm going to misrepresent this to the court in my fraudulent filing here and hope they don't notice. But that's enough for me to talk about this right now, and I'll just conclude that I as intervening non-appearing counsel and counsel for Miss Owens is appearing non-appearing counsel. You know, that's sort of like a ghost. Sort of like a ghostly intervener. I can appear and disappear as I so desire and represent and not represent Laura as I so see fit. I request all that, and I dated that September 12th of 25. Signed, Dingus Douche Canoe.
The fucking douche canoe.
Okay, we've been going for roughly an hour. My voice needs a break after all that. It's not often I read so much in douche canoe voice. Or could that be Southwestern douche canoe voice? I'll have to come up with a name for that. So I'm going to take a little pause. I'll get to the next finally after this. Let's call this part 1, and we'll continue with the next one, which is even more egregious than this thing, as part 2. So stay tuned as we watch David S. Gingras have a hate boner for YouTubers.